Hi, everyone. Thank you for joining. My name is Jordan Cardenas. I'm an attorney here at the Compliance Center, and I'm super excited to present to everyone today. And think we have a fun and interesting topic. So we'll be going over employee and worker classifications. So to start, classifying workers. When you hire someone, determining whether they can be classified as an independent contractor or whether they must be classified as an employee. And we'll go through the different kind of independent contractor tests. And as you will see, this is a very fact intensive process, and there's a multitude of different tests that could apply. So it makes it pretty complicated and not employer friendly. And we'll talk about best practices on how to properly classify someone as an independent contractor. And then we'll talk about classifying employees. So when you do classify someone as an employee, the next question becomes, is this person exempt or non-exempt? And kind of generally speaking, exempt are usually salaried employees, and the non-exempt are usually hourly employees. So we'll go through the different exemptions, and then we'll kind of go through some classification errors as well and some best practices. So to start, independent contractors. So independent contractors, they typically own their own business and they provide services on their own terms. So when someone hires an independent contractor, the independent contractor's customer, they control the goal. So you hire a worker for a specific task, but then the independent contractor, they will control the means to accomplish the goal. So the day-to-day work is controlled by the independent contractor, not the company or the customer. And the independent contractor is typically engaged only for a specific period of time. So then their relationship ends after 6 months, 1 year, whatever the time frame is, or after a specific task is completed. Independent contractor, they retain economic independence, meaning they offer their services to a bunch of other customers in the marketplace. And then the independent contractor, they're responsible for paying their own income, Social Security, and Medicare taxes. Obviously, they do that through 1099. And whereas employees, they're subject to W-2 withholdings. And then independent contractors, they're generally not protected by employment laws. So they're not entitled to paid sick time. They're not necessarily entitled to like Minnesota paid leave and other employment protections. So, an independent contractor, they usually do not perform the same work as employees. So, if you have a group of individuals, a subset of them are doing classified as employees, and a different subset are classified as independent contractors, but they're both performing the same work, that's a red flag that they could potentially be misclassified as independent contractors. And then the independent contractors, they don't have the signs of an employee. So the person that hires an independent contractor, they shouldn't provide company uniforms, name badges, business cards, company emails. That should only be given to employees and not to independent contractors. And then, like I just said, independent contractors don't receive company provided benefits such as paid vacation time, PTO, health insurance, and then other benefits. Okay, so when you're determining whether to classify someone as an independent contractor, you can't solely rely on your agreement with that person to classify them as an independent contractor. So that's kind of irrelevant to determine whether someone's properly classified. And as you'll see about the test we talk about, there's a multitude of factors that the government looks at to determine whether someone is properly classified. So just because you have a contract agreeing for someone to be classified as an independent contractor, the government or a court could say that's not binding, it's irrelevant, and then still determine there is a misclassification. So the important part of classifying employees is looking at the facts, or classifying workers is looking at the facts of the scenario. So it's a very fact intensive analysis. So you have to look at the day-to-day activities the worker will perform and then make a determination whether they should be classified as an employee or whether an independent contractor status is permissible. So employees, on the other hand, they're subject to significant company oversight. So the company controls the goal to be accomplished, and then they generally control the means to accomplish the goal. So whereas an independent contractor, the independent contractor controls the means to accomplish the goal. Employees, the company controls the means to accomplish the goal. So the company might say you have to follow this task, these procedures, these policies. So they're exercising a significant amount of control. So that favors employee status. And then obviously the employees would be paid wages. They're eligible for company benefits. They have their W-2 employment taxes withheld. And then they're generally economically dependent on the employer. So usually most employees, they just have one company that they work for, whereas independent contractors, they solicit their services to the marketplace in hopes of being hired by many companies. Okay, so some common misconceptions. Probably the most common one we hear at the Compliance Center is, well, I classify them as a 1099 employee. And unfortunately, that's an oxymoron. There's no such thing. So the person is either an independent contractor, a 1099, or they're a W-2 employee. So you can't combine them into one. It's an either or scenario. And then sometimes we hear, well, I'm a small business. I only have 5 to 10 employees, so I'm not required to, or I'm allowed to classify them as an independent contractor. And that's not the case, unfortunately. So the tests that we'll talk about are applicable to businesses of all sizes, no matter how big or how small. And then sometimes we hear, well, we classify them as an independent contractor because everyone else in the industry does it. And that's not relevant when determining whether someone can be classified as an independent contractor. It is solely determined by the applicable test, which we'll talk about. And then sometimes we see, well, the person is going from full-time to part-time, so we're just going to classify them as an independent contractor. And that can be a big red flag and usually not permissible. And then, like I said earlier, well, we have an agreement that classifies them as an independent contractor, and the agreement itself is not enough to properly classify someone as an independent contractor. Okay, so as you can see on the slide, there's different tests to determine whether someone is an independent contractor. And it's complicated because the applicable test will be determined by who's looking at the issue. So you have the U.S. Department of Labor's Economic Realities Test, and this is a 6-factor balancing test. So if you're being investigated or you're in a lawsuit with the U.S. DOL, they have their own test to determine wage and hour issues. The IRS has their own test for tax issues. There are something called common law tests, basically tests made by judges throughout the country. And then there's different tests depending on which state the employee is in. So like California, New Jersey, for example, they have something called the ABC test. We won't get into it today, but it's a very employee-friendly test. In other words, it's very hard to classify someone as an independent contractor in California and New Jersey. And in Minnesota, they don't make it any easier. So we have about 5 different tests depending on the issue. So there's a test used by Minnesota DOLI for wage and hour issues. There's a different test for unemployment, different test for workers' comp, different test for state taxes by the Department of Revenue, and then there's another test for the construction industry. And just kind of a quick plug for the construction industry test. If there's anyone here in the construction industry, just know there was a significant law passed 2 years ago where the state passed a 14-element independent contractor test. So in this presentation, we'll talk about the U.S. DOL and then the Minnesota DOLI independent contractors test, and those are balancing tests. So the courts or those agencies look at the factors and determine whether it weighs in favor of independent contractor or employee. But the construction industry is different. Instead of 14 factors, there's 14 elements, meaning all 14 elements need to be satisfied in order to properly classify someone as an independent contractor in the construction industry. So it's a big, complicated test, so please contact us if you have any questions, but just know it exists. So to start, let's talk about Minnesota's test when looking at state wage claims. So oftentimes missed overtime or missed minimum wage. So I believe there's about 8 or 9 different factors. And again, it's a balancing test. So no one factor is determinative. Rather, after going through all 9 factors, the state would decide, okay, does it lean in favor of employee or does it lean in favor of independent contractor status? And kind of the one that gets the most attention is the first one. So the degree of control over the manner and method of work. So in simple terms, the more control the company has over a worker, then that favors employee status. The less control the company has over a worker, that favors independent contractor status. So if their control exists when the individual is required to comply with instructions about when, where, and how to complete the work, in other words, if the company controls the means to complete the goal or the work, that favors employee status. If the work can be done elsewhere, but the work is still required to be completed on the company's premises, that favors control and therefore favors employee status. If there's a continuing relationship, so it's indefinite, there's no set end period, that favors employee status. And then if the company sets the worker's hours of work. So if you have to be here 8 to 5, Monday through Friday, that's obviously a significant degree of control. So that favors employee status. And then even more kind of sub factors of the control factor is the worker required to do trainings, go to company meetings, that favors employee status. Is the person required to devote their full time to the business? In other words, they can't compete with the business while employed by the business. That would favor employee status. And then how many companies does the person work for? This is just one company. That favors employee status. If the person is working for 10 to 15 different companies and offering very specific services for each of those companies, then that would favor independent contractor status. And then some other 2 common ones we see is who provides the tools, materials, supplies, and are there any reimbursements? So if the company gives the worker tools and materials to complete the project, that's going to favor employee status. Whereas if the person provides their own tools, their own supplies, that's going to favor independent contractor status. And then if the company reimburses the person for travel expenses or any other expenses, then that would favor employee status. So all these 2 slides, that's just for one factor. That's just for control. And the other ones are a little more simple. So the second one is the right to discharge. So if the person can basically leave without notice, that favors employee. It's like at-will employment. If the relationship ends after completing a project, that favors independent contractor. Or if it were to end after a specific period of time, say 6 months, 1 year, that can favor independent contractor. And does the person make their services available to the public? So if you have someone, they have their own business, they're offering to sell their services online, and a bunch of different people hire them, that's going to favor independent contractor status. So oftentimes in that scenario, the person has their own office, they have their own employees, have their own assistants, they have a physical store, a business phone line, things of that nature. And then payment. This is an important one. So if you're paying someone by the hour, you're giving them commissions, they get a biweekly paycheck, that's going to favor employee status. Whereas independent contractors, they're usually paid like a flat fee or maybe some installment payments as the project progresses. So if you have a flat fee or some type of installment payments, you're not paying by the hour, you're not paying overtime, that favors independent contractor status. The realization of profit or loss as a result of the services. In other words, does the worker have skin in the game when performing the services? If yes, that's going to favor independent contractor. So usually how this works is you hire someone and they have their own business and if they perform poorly, then that can somehow affect their business reputation and affect them in the marketplace. And again, if they have their own office, equipment, materials, that would be they're obviously investing their own capital, their own contributions. So then if the project doesn't work out, that could be a big detriment, loss to the worker. So then that would favor independent contractor status. Sixth one, very similar to the right to discharge. The state just calls it termination. So the individual's right to terminate at will, and they can't get sued for liability for terminating early or not completing a project. That would just favor employee status. Whereas independent contractors, they're usually hired to perform a very specific task. And in that way, if they terminate early or they don't complete the task, then the hiring company could sue them for breach of contract. So then that would favor independent contractor. The last three, so substantial investment, kind of related to the realization of profit and loss. So does the person have skin in the game? So if they made a substantial investment into the project, they provided their own capital, any other contributions, tools, materials, equipment, that would favor independent contractor. And then responsibility. Who's responsible for the individual's work? If the hiring company is responsible for any work performed, whether it be negligent work or any injuries incurred, then that favors employee status. Whereas if the individual himself or herself, they're personally responsible or their own business is responsible for the work performed, then that's going to favor independent contractor status. And another key one, and this is a key one that we'll talk about with the US DOL test, is are the services fundamental or essential to the business? So if you hire someone and they perform services that your business needs or it's an essential part of what you offer to your own customers, then that's going to favor employee status. So, for example, as a law firm, if we hire someone to perform legal services, they're a lawyer, they go to court, that obviously would be an essential service our firm offers. So then that would favor employee status. Whereas if we need to hire or update our website and we hire a website designer, that person is going to that's going to favor independent contractor status because website design is not an essential part of our law firm's business. Okay, so that was the Minnesota test for wage and hour issues. And now we'll turn to the US Department of Labor test for wage and hour issues. So when you're trying to classify someone, at least in Minnesota, as an independent contractor, you'll want to look at both tests. So the U.S. Department of Labor has only 6 factors instead of 9, but as you'll see, there's a lot of overlap. So the one we just talked about, the extent to which the services rendered are an integral or an essential part of the business. Against the example I just gave, the website designer, that's not an essential part to our firm's business, so that would favor independent contractor status. And then the permanency of the relationship, this is similar to the right to discharge and the termination factors under Minnesota law. So if the termination or the relationship is indefinite, there's no set end date, that's going to favor employee status. Whereas if the relationship ends after completing a certain task or after a certain time frame, that's going to favor independent contractor status. The amount of the worker's investment in facilities and equipment. So does the person provide their own capital, their own tools, materials, supplies? If so, that's going to favor independent contractor. And if they don't provide those things, that's going to favor employee status. And then the amount of skill and business initiative required. So if you need to hire someone with a very specific skill set that no one else at your company can perform, then that's going to favor independent contractor status. So that would relate to the example I gave with the website designer. So no one at our firm knows how to properly or professionally update or create a website. So we need to hire someone with a special skill to perform those services. So then when we hire the website designer, that would just be an additional factor that would lean in favor of classifying that person as an independent contractor. And then same as Minnesota, the nature and degree of control. So who's controlling the person's work schedule, the work hours, how they perform certain tasks. The more control the company has, then that favors employee status. The less control favors independent contractor status. And then similar to the Minnesota test, the worker's opportunities for profit and loss depending on the needed skill. So again, does the person have skin in the game? So is there potential that they provide their own contribution to the project, and if the project doesn't work out, do they incur some type of loss or vice versa? If it works out and they incur some type of profit, that would favor independent contractor status. So the tests in the federal test and the Minnesota test, they're substantially similar. So in most cases, a employee would if you can properly classify an independent contractor, it's usually a scenario where you can satisfy both tests. But just make sure when you're doing that analysis that you go through the 6 factors with the US DOL test and then the 9 factors under the Minnesota DOL test. Okay, so I have 2 examples. First one, we have a nurse who provides nursing care at Horizon Nursing Home. So Horizon is a nursing home facility. They set the nurse's work schedule with staff preferences and determine staff assignments. And then Horizon, their policy prohibits the nurse from working for other nursing homes while employed at Horizon. The nurse is supervised by regular check-ins with managers, but the nurse generally performs their work without direct supervision. And then Horizon pays the nurse by the hour, and Horizon provides the nurse with health insurance. So the question is this person an employee or an independent contractor? And most likely they're an employee. So when we're going through the factor analysis, again, balancing tests. So we're trying to determine, does it weigh in favor of employee or does it weigh in favor of independent contractor status? So when looking at kind of the first factor is the work essential to the business? And here, yes. So it would favor employee status. So you have Horizon Nursing Home. Their essential service is providing nursing services, and then they hire someone to perform just that, nursing services. So that favors employee status. The degree of control, this favors employee status because Horizon is setting the nurse's work schedule, determining staff assignments, and then the nurse is prohibited from working for any other nursing home while employed at Horizon. And then the payment method, so this is kind of a factor just applicable under Minnesota. The nurse is paid by the hour, so that would favor employee status. Okay, example number 2, we have Adam, and Adam owns his own company called Adam Therapy LLC. Adam is a nurse who works at Therapy House. So Therapy House provides specialty movement therapy to residents. So Adam has his own website, and he was contacted by Therapy House to assist its residents. Adam provides movement therapy for residents on a schedule agreed between Adam and the resident. So it's not Adam and Therapy House, it's Adam and the resident that agree to terms. Without direction or supervision from Therapy House, Adam sets his price for his services on his website, and then Adam also provides services to other nursing homes and healthcare facilities. Is Adam an employee or an independent contractor? So here, he's most likely an independent contractor. So when we're going through the factors, one we have to look at is the essential services factor. So here, this factor actually weighs in favor of employee status because the therapy company, they perform therapy nursing services, and then they hired Adam to perform kind of those same services. So that would favor employee status, but that's by itself is not enough. Because remember, it's a balancing test, so we have to look at all the other factors. And all the other factors here would weigh in favor of independent contractor status. So degree of control, Adam works for other healthcare facilities, so he's not prohibited while working for the therapy company. And then Adam determines his own pricing with residents. And then Therapy House does not control the means of how Adam provides his services to residents. So Therapy House might say, hey, the goal is to provide therapy or nursing services, but then you control how you actually perform those services with the residents. So having control over the means of the goal, that favors independent contractor status. And then kind of the make your services available to the public, the opportunity for profit and loss. Here, Adam has his own LLC, He solicits his services, so he has a bunch of different clients other than Therapy House, and he can determine his own pricing. And then if he does well, that can benefit him because it can get him referrals. And then if he does poorly, that can be a detriment or a loss to him because now his business reputation can be harmed. In the future, obviously making it less likely he gets hired by someone else. So here, even though you have the one factor in favor of employee status, the other factors weigh in favor of independent contractor status. Okay, so why is this important? So there can be some major consequences when if you improperly classify someone as an independent contractor and they should have been classified as an employee. So to start, when you improperly classify someone as an independent contractor, you could potentially have years of unpaid federal, state, and local income tax withholdings. It can be a Social Security, unemployment, and Medicare contributions that you missed. You're not recording their work time, which is required when you have non-exempt employees. And then you're not complying with employment laws. So the person's not getting overtime, they're not getting minimum wage, they're not getting paid sick time, and they're not getting FMLA, ADA. All those protections don't apply to independent contractors. So then it can be a major issue if you do misclassify someone and they were entitled to those benefits and protections. And in Minnesota, they kind of have a scary statute. And it actually says that the owner, partner, principal, member, or agent of a business who knowingly or repeatedly misclassifies someone as an independent contractor, they can actually be held individually liable. So usually someone is misclassified and just the business itself is responsible for paying the damages. But in Minnesota, the statute says if you have an individual who knowingly or repeatedly misclassifies someone, then that could be a scenario where you're personally responsible for paying damages to the misclassified worker. Okay, so some of the damages that a misclassified person can receive. So you classified them as an independent contractor, but they should have been classified as an employee. So they get the difference between what they should have been paid as an employee. So any missed minimum wage, overtime, shift differentials, vacation and sick time. They get the value of benefits if you offer those benefits, such as health insurance, life and disability insurance, and retirement plans. They get the value of employer contributions to unemployment insurance, Social Security, and Medicare. And then there's a catch-all provision saying any other costs and expenses incurred by the worker resulting from the misclassification. So that can mean a multitude of things. So if they can show that they incurred some monetary damage because they were misclassified, then they can try to hold the company responsible to reimburse those costs and expenses incurred. And then in addition to that, the state can impose a $10,000 fine for each employee misclassified as an independent contractor. So how can we prevent this? So some best practices. When you do hire someone as an independent contractor, you always want to have an agreement. Again, the agreement itself is not sufficient, but it's one of the many factors that can help you establish independent contractor status. So make sure you have a detailed independent contractor agreement, and then you give that person a 1099. And then avoid using both employees and independent contractors to perform the same work. So again, usually someone hires an independent contractor and that person is performing services that are essential or integral to the business, and that's going to favor employee status. So your independent contractors should not be performing the same work as your employees. And then you want to pay your contractors by a flat fee after completing the project, installment payments, but don't pay them by the hour. And then obviously you don't want to reimburse them for any business expenses. And a big one here, don't give independent contractors company emails, company tools, business cards, or a uniform. And then don't provide them with employee benefits. So like your handbook, for example, should never mention independent contractors because that is All the policies in the handbook, that's solely for employees, not independent contractors. You don't want to schedule their work hours or their work days. Technically, the independent contractor has control over that. Don't invite them to company meetings, company events, and then don't control the means of their work. Now, that's not to say you can't, they still have to perform satisfactory work, but you just can't control the means of how they complete the work. Okay, so transitioning to non-exempt and exempt employees. So if you have a worker, you decide, hey, you're an employee. The next major question is this person non-exempt or is this person exempt? So, kind of some background on the exemption laws. So, we had the Federal Fair Labor Standards Act, and this is the federal statute that governs wage and hour issues for all public and private employers in the US. And then Minnesota, we also have a state Fair Labor Standards Act, and it does differ than the federal FLSA in certain ways. But generally speaking, so non-exempt employees are not exempt from the FLSA. Non-exempt meaning now they're entitled to overtime and minimum wage and all other protections under the FLSA. Whereas exempt employees, they're exempt from the FLSA. So they're exempt from overtime, they're exempt from minimum wage, and exempt from all other FLSA protections. So proper classifications is very important because employees who are misclassified can then recover for unpaid wages, which includes overtime, liquidated damages, and that just means double damages. So whatever their actual damages are, you times it by 2. And then there's a attorney fee shifting provision. So then the company can actually be responsible for paying the employee's attorney's fees that they incurred in bringing the lawsuit, which is oftentimes over 6 figures if it goes to trial. And then 2025, the US DOL, they collected almost $260 million in back wages for 177,000 employees. So then if you have an incorrect classification, the DOL can do an audit and then they can look at all your employees. And the big thing here is that sometimes these wage and hour issues, so missed overtime, missed minimum wage, is not covered by EPLI insurance. Sometimes I think you have to purchase like an additional rider. So that's something to double check to make sure if you do have EPLI, that's something worth checking to see if it covers wage and hour issues. Because oftentimes a wage and hour lawsuit turns into a class action because if you're misclassifying one employee, the odds of misclassifying more than one is pretty high. So it can turn into a class action where many people sue at once, and then the damages number can get extremely high. So, kind of some general requirements. So when you have a non-exempt employee, you must comply with all minimum wage and overtime requirements, and you need to track their hours worked in addition to all other requirements under the FLSA. But those are kind of the two general ones. And then not exempt employees, they're exempt from minimum wage and overtime. So if you have someone that's exempt, and we'll get into this later, like an outside sales position, they could be 100% commissioned and you don't have to, and they work 100 hours a week. You don't have to pay them minimum wage and you don't have to pay them overtime. But the key here is that exempt employees, there's generally 2 different tests that need to be satisfied. And we'll talk about that. But one is called the salary test, and the other is called the job duties test. And usually, for most exemptions, you have to satisfy both tests in order to properly classify someone as an exempt employee. So non-exempt, just be aware there can be some conflicting laws because like I said before, there's a federal FLSA and then many states have their own kind of mini FLSA statutes. And there can be some different laws that conflict with each other, depending on what state you're in, that can conflict with the federal FLSA. So, for example, when we're looking at overtime, the federal FLSA requires you pay employees time and a half if they work over 40 hours in a work week. Minnesota, in contrast, you only have to pay employees time and a half if they work 48 hours or more in a work week. So obviously there's a conflict there. Whereas if you're in Colorado, you have to pay someone time and a half if they work over 40 hours in a work week, or more than 12 hours in a workday, or 12 consecutive hours in a day, whichever results in the largest payment to the employee. So when you have this scenario where you have a state law conflicting with the federal law, you have to comply with the law that's more employee friendly. So in Minnesota, for example, you have to pay people, your workers, time and a half because the federal FLSA is more employee friendly than the Minnesota FLSA. Whereas Colorado, there could be instances where someone gets overtime in Colorado that's not required under the federal FLSA. And in that case, you would have to comply with Colorado law because Colorado would be more employee friendly. Okay, so the two different tests for the exemptions is that you have the salary basis test and then the job duties test. So the salary basis test, there's kind of two subparts to that. So the first one is the employee must receive a predetermined amount regardless of the quantity or quality of work. So in other words, they have to get the same paycheck every week, regardless of how many hours they work or regardless of whether how well or how poor the work is. So if you have an exempt employee, you pay them $900 a week and they work 40 hours one week, they get $900. If they only work 30 hours one week, then they are still entitled to $900 because the quantity of work cannot affect their salary payment. Now, there's exceptions to that for deductions, and if we have time, we'll get into that at the end. But generally speaking, they must get the same pay every week. And then there's a salary amount requirement. So they have to receive at least $684 per week, or about $35,500 in the year. So if you satisfy those two subparts, you satisfy the salary basis test, but then generally the employee must also satisfy the job duties test. And there's different job duties tests for different exemptions. So we have the executive exemption, administrative exemption, the professional exemption, and others. And each of those exemptions have their own applicable duties test. So you would have to satisfy the duties test for the applicable exemption. And then in addition to that, satisfy the salary basis test. And if those two tests are satisfied, then you can classify the worker as an exempt employee. Okay, so now we'll kind of go through the different or kind of the main exemptions. So the first one being the executive exemption. So again, you have to satisfy the salary basis test, and then you have to satisfy the job duties test. And under the executive exemption, there's three different requirements for the job duties, and all three must be satisfied. So the first one, the employee's primary duty is managing the business or a department or subdivision of the business. So primary duty means it's the main or major part of the worker's employment, of their job duties. So managing in this scenario can mean interviewing, selecting and training employees, disciplining employees, planning the work schedule, planning and controlling budgeting, anything that would be considered managerial. So that would be the primary duty. And then the employees must normally direct the work of at least two or more full-time employees or their equivalent. So basically, you have to manage or supervise at least two full-time employees or their equivalent. So that could be four part-time employees. So that would add up to two full-time employees. So at least two full-time employees. And the third requirement is that the employee must have the authority to either decide or influence who gets hired, fired, and or promoted in the workplace. So if you just have the authority to do it, great, you satisfy the third requirement. But oftentimes the more nuanced approach or scenario is the particular weight. So someone would have the particular weight if their job duties include recommending, hiring, or firing someone, and they're frequently relied upon by upper management to make those decisions. So if you satisfy the salary test, you satisfy all three of these requirements under the job duties test, then the person can be classified under the executive exemption. Now, a common error we see is that, oh, the person is classified as a supervisor, so then they're automatically deemed under the executive exemption. But that's usually not the case because oftentimes that supervisor doesn't have the authority to hire or fire someone, or their input is never sought. And then oftentimes they only supervise like one person. So they're not directing the work of at least two full-time employees. And then the other one would be the administrative exemption. So again, you have to satisfy the job duties or the salary basis test. And then there's the job duties test. So the job duty would be the primary duty must be performing office or non-manual work. So it can't be physical labor. And it has to be directly related to the management or general business operations. And management, that's basically the same as the executive exemption. So do they control the taxes, financing, accounting, budgeting, advertising, marketing, human resources, employee benefits, any other things that would be considered management? And they have the ability to exercise discretion and independent judgment regarding significant business decisions. So in other words, do they have the authority to create and implement policies? Do they have the authority to kind of deviate from policies and use their own discretion and enforcing policies as well? So an example of this would be the head HR director at a company. That person would likely or would satisfy the administrative exemption because the head of HR, they determine what policy the companies are going to implement, how to enforce them, and then they have discretion on managing the company, obviously with hiring employees and firing employees. Whereas if you have just kind of like an HR assistant, that person usually does not have discretion or the ability to exercise independent judgment because the HR director tells the HR assistants, here are all the policies you must comply with. You have to follow it to a T. You have no discretion, things like that. And then as another example, a staff accountant. So someone has specialized training and uses personal judgment and discretion when determining kind of the budget of the company, what to purchase, what loans to obtain. That could satisfy the administrative exemption because they have the ability to exercise discretion and independent judgment. Whereas a bookkeeper, they're usually not able to be classified under the administrative exemption because they typically handle kind of accounting or bookkeeping matters according to company policy or company standards, and there's really no discretion for them to deviate from those policies or practices. And another common error we see is that someone just has the title administrative assistant or some other job title that says administrative or another type of assistant. And again, job title, that alone is not sufficient to classify someone under an exemption. You have to look at their job duties, what they do day to day, and then make sure they're satisfying the salary basis test. The professional exemption, so a little less common, but again, there's a salary basis test for the professional exemption, and then the job duties test. So the employee's primary duty must be predominantly intellectual. So it can't be manual labor. It has to be in a field of science or learning. So this could be things like medicine, accounting, the legal world, architecture, engineering, things of that nature. And then it must be normally acquired, the specialized knowledge must be acquired through a specialized intellectual instruction. In other words, you have to have some type of advanced degree. So if you have your doctorate, master's, or any other advanced degree, then that would satisfy this third requirement. So most oftentimes this only applies to certain educators, physician assistants, other workers in the healthcare, obviously doctors and lawyers. So it applies to a lot of people that have their master's or any other advanced degree. So the computer employee exemption, we see a lot of confusion with this exemption. So this one is a little more unique because in addition to the salary basis test, you could pay them by the hour. So if you don't want to pay them a salary, you could pay them by the hour as long as you pay them at least $27.63 per hour. then you would satisfy the first part. And then there's also a job duties test. And I won't get into it, kind of all the details, but because it's pretty technical. But just know this exemption does not apply to IT support or kind of like any general IT worker. It doesn't apply to people who kind of repair or manufacture like computer hardware or any type of computer systems. This exemption is limited to people who are actually creating like the computer software, computer programming, the coding. So it's very technical work. And like the most common examples would be software engineers and computer programmers. So it's not applicable to kind of your general IT support in the workplace. Outside sales. So we see a lot of confusion with this exemption as well. So outside sales is not to be confused with inside sales. So inside sales, there is no exemption. The exemption only applies to outside sales. And this one is a little more unique because there's no salary basis test. There's only a job duties test. So for this one, the employee's primary duty must be basically making sales, and the employee must normally work away from the employer's place of business. So, in other words, they have to be traveling, going door to door, going to different customers, and making sales on the road. So, it doesn't apply to anyone in your office that's making sales calls, and it doesn't apply to anyone working remotely. So, if you have someone out of state or they're just working from home, that is not considered outside sales because they're not away from their workplace. So if someone's working from home, their workplace is at home or so with the business, and they need to be traveling. So the most common example or a common example is people in the medical sales business that are going to hospitals and other healthcare facilities throughout the state or throughout the country, and they're not at a desk all day making phone calls. That medical salesperson would satisfy the outside sales exemption. And Minnesota is a little unique because under the our Minnesota FLSA statute, it says that the employee must be away from their workplace making sales at least 80% of the time. So it's not 50-50. So their primary duty has to be away from the workplace making sales. And Minnesota generally says you generally have to be away 80% of the time. Okay, so last one, the highly compensated employee exemption. So this would apply to someone that makes at least $107,432 in a year. And then there's also a job duties test. So if the employee's primary duty includes performing office or non-manual work, and they perform at least one of the exempt duties under the executive, administrative, or professional exemptions. So some common errors we see is that I classified someone or I'm paying someone a salary, so they're automatically deemed exempt. There's a lot of problems with that. So first, if you're paying them a salary, are you still satisfying the salary basis test? So is it a predetermined amount? And then are they getting the requisite amount they needed per week in order to hit about $35,500 in a year? And then making classifications based on job titles. So if you label someone as a manager or a supervisor, that does not automatically mean they can be classified under the executive exemption. Same thing if you classify someone as an administrative assistant, that doesn't mean you can classify them under the administrative exemption. Or kind of relying on incidental or occasional duties in making the classification. So for example, when we're looking at the executive exemption, one of the requirements is the person has to normally direct the work of at least 2 full-time employees. So if you have an employee that will sometimes step in and supervise a team of employees maybe once a month as someone is out, and that person only does it in certain scenarios where they're supervising at least 2 or more employees, that would not satisfy the element under the executive exemption because it has to be the primary duty and it can't be occasional work. Again, primary means it's the main or the principal part of their job. And then failing to consider state law. So we didn't get into it today, but some states, for example, have a higher salary threshold than the federal statute. So the salary basis test under the federal FLSA, the employee has to get paid at least $684 per week. But in states like New York and Colorado, they have a higher salary threshold that you have to pay employees, which makes it harder to classify them as exempt. So just be aware of those nuances. And then as an example, so we have Taylor, who is a shift supervisor for a production company, but upper management occasionally seeks her opinion on firing decisions. She often works over 60 hours per week, making $900 per, or excuse me, works over 60 hours per week and makes $900 per week. Her main duties include running production lines, performing maintenance as required, and she occasionally directs the work of two other people on her work line. And the company classifies her as exempt under the executive exemption. Is she properly classified? So here she would be misclassified. So she satisfies the salary basis test. So she's making $900 per week. So that's more than the $684 amount. But she's not satisfying any of the applicable job duties tests under the exemptions. So with the executive exemption, her primary duty is not managing the business. She's on the production line. She's performing repairs. She's not involved in taxes, financing, hiring and firing. So she wouldn't satisfy that. And she occasionally directs the work of at least two other employees. So under the executive exemption, the person has to normally direct the work of two or more employees. So in other words, being a supervisor has to be part of your job duties. So in this case, she's a student occasionally, so that would not be considered a primary job duty. And then under the administrative exemption, she can't be classified under that exemption because she's performing physical labor. And under the administrative exemption, one of the job duty requirements is that the primary duty has to be office or non-manual work. So the administrative exemption would not be applicable here. Computer exemption doesn't apply. The professional exemption obviously doesn't apply. And then the outside sales doesn't apply. She's not making sales. So in this case, she would have to be classified as a non-exempt employee. And just as an example of kind of what the damages could be in a situation like this, so let's assume in Taylor's case, there are 10 other supervisors and they are all involved in a class action against the company. And they all been employed for at least 1 or 2 years, and they're working the same number of hours and receive the same pay as Taylor. So that they work 60 hours per week. So if Taylor's making $900 per week and she's working 60 hours per week, her regular rate of pay would be $15 an hour. So then her overtime rate would be $22.50. And she's working 60 hours in a work week. So she's then entitled to 20 hours of overtime. So that would be $450 per week that she has not been paid. And if you do that in a 1-year period, that would be $23,400. That's just owed to one employee. So then if those 9 other employees were to sue, that total amount for just 1 year missed of overtime would be over $200,000. So if they were to sue and they were to win, they would at least at minimum get the miss overtime. And then if a court found that the misclassification was willful, intentional, then the court could award liquidated damages, which just means double damages. And now the amount is over $460,000. And then again, if a former employee or current employee wins in a wage and hour lawsuit, they can be entitled to payment of their attorney's fees. And attorney's fees are often over 6 figures in cases like this. So it could be an extraordinary high number, which is why it's so important to properly classify them. So kind of some clarification on the exemptions. So the FLSA does not require that an employee be classified as exempt, even if the applicable exemption test applies. So in other words, the exemptions are permissive. They're not mandatory. So if you have someone you think, hey, they can be classified as exempt, you can still classify them as non-exempt. Rather, the FLSA only prohibits misclassifying non-exempt employees as exempt because the damages that occur there would be the miss overtime and the miss minimum wage. So you can't have a non-exempt be classified as an exempt, but you can have an exempt employee be classified as non-exempt. Okay, quickly about deductions. So the general rule is that the employee must receive their entire salary if the employee performs any work in the work week. So in other words, there's only very specific instances that deductions are allowed for salaried employees. And those deductions are, I think there's about 6 different ones. So you can do a deduction from a salaried employee's pay if that employee is absent for one or more full work days for personal reasons other than sickness or disability. So it has to be at least one or more full days. So if they're gone for a half a day, you can't do a deduction. Or you could do a deduction if they're absent for one or more full days due to sickness, as long as the company kind of has a bona fide plan, policy, or practice about that. In other words, your sick time policy clarifies that you can make a deduction in this scenario. And then you can do a deduction to offset any amount the employee receives for jury duty or as a witness fee in a case or any type of military duty pay. You can do deductions for penalties imposed in good faith if they violate any safety rules at the company. You can do a deduction if you put them on unpaid leave for one or more days for a discipline issue. You can do a deduction in the employee's initial or last week of employment if the employee does not work the full week. And then the federal FMLA permits deductions when the employee is taking FMLA leave. So just kind of quickly, I know we're getting up to the time. So some examples of illegal deductions. So you can't do a deduction from pay when the employee is absent for a personal or sick time reason for half of the day. So again, the sick time reason or the personal leave has to be for one or more full days. So if you have someone that's absent for 4 hours out of an 8-hour work period, you can't do a deduction. You can't do a deduction pay when the employer is closed due to poor weather. So the rule there is if the employee is ready and able to work, you can't make a deduction. So you can't deduct from their pay if the company is not working due to a reason not caused by the employee. You can't do, or you do a deduction for 3 days pay because the exempt employee was absent for jury duty and that employee did not receive any jury duty pay. So the deductions, it's very important you don't make any illegal deductions because it can have some significant consequences. So if there is an illegal deduction, you can obviously remedy it by reimbursing the employee by paying back the deduction you took. But if there is a practice of making illegal deductions, that can cause the employee and then all other employees with the same job classification to lose their exemption status. So if you have some type of practice that you implement and it ends up deducting illegally from exempt employees' paychecks, then you can lose that exemption for all of those employees. And that turns into an issue now of missed overtime and missed minimum wage. So there is a safe harbor allowed under the federal FLSA. And basically what it is says if the company has a policy saying they won't make illegal deductions, and if they happen to make an illegal deduction, they are committed to reimbursing that amount. And that policy, if it's implemented, is meant to act as a safe harbor to prevent employees from losing their exempt status. So there's a few requirements. So the safe harbor policy should prohibit illegal deductions, and there should be some type of complaint procedure. So if an employee believes there's an illegal deduction, do they contact HR? Do they contact someone in accounting? And this policy should be in the employee handbook. And then the second requirement, the employer says, hey, if there is an illegal deduction, we'll make it right. We will reimburse you for the deduction amount. And then the employer makes a good faith commitment to be compliant in the future. So some best practices when classifying employees as exempt or non-exempt. Um, in some instances, if you're kind of like, it's a little bit gray, I don't know if this person is misclassified or not, you can do a company audit. So you can look at all the employees you classified as exempt, and you'll want to look at their day-to-day activities. So you want to see, are they satisfying the primary job duties test for the applicable exemption? And you can do this by, you can shadow the employee in the workday. You can interview the employee to get a description of what they do, interview their supervisor, and then update job descriptions. So if you're going to classify someone under the executive exemption, you'll want to put in the job description what manager duties do they have, clarify whether they'll be responsible for supervising at least two or more employees or a team of employees, things like that. Um, Clarify your classification offer letter. So in Minnesota, we have to give employees the Minnesota wage notice. So in that notice, you should tell employees, and it's required, whether they're exempt or non-exempt, and then make sure you're checking state law. So especially kind of if you're in any of the states on either coast, like so California, New York, and even Colorado, they have different requirements that make it harder to classify someone as an exempt employee. For example, the federal DOL salary test says the employee has to get $684 per week, or at least. But California and New York, they have a higher dollar threshold, which makes it harder to classify employees as exempt. And then the safe harbor policy, we highly recommend at the Compliance Center to include that policy in the handbook to avoid losing the exempt status for certain employees if you happen to accidentally make an illegal deduction. Well, that's all I have. So thank you everyone for attending. If you have any questions, please reach out to the Compliance Center. We're super happy to help. So if you have any questions about independent contractors, exempt versus non-exempt, just let us know. And thank you again for attending. And I hope everyone has a great rest of their day.